see what she has.
Yeah,
if
I'm
she
gonna
has.
see who I don't.
Here comes another one. Here's another one.
Snow.
Yes.
So I've got Snow.
Why am I not
I
seeing?
have Key.
Yes.
Oh yeah, we'll
I'll have to spin the closet and then do it.
All right, councils, good morning. We have a whole bunch of dependency stuff, but in an effort to be cognizant of your time, we'll go through your cases first. Mr. Seltzer, what's your client's name? Urban Etienne on page 24 of your Etienne. Etienne, what facility is he at? In jail.
Alright, so I've got everyone.
Yeah, that was
Etienne, come to the podium, please.
Yeah, during the week, yeah.
Mr. Etienne.
Coming up, George.
All right, good morning. Mr. Etienne, good morning. My name's John Fry. I'm a judge here in the 17th Circuit. Your attorney is present, although you don't see him. He's been here for approximately an hour trying to help you out. So, on Mr. Etienne's case, I have 2 felony violations of probation, no bond. Are you aware of that, Mr. Seltzer?
Yes, Judge, I am. I had not been aware of the existence of a new felony charge,
Okay.
introducing contraband into the corrections facility. Before I had walked into the courtroom, I had only been told by his family that he had 4 or 5 grams of marijuana as a result of a traffic stop, was the allegation. And I had hoped to be able to obtain a bond based on that misdemeanor offense. But in light of the felony charge and the 2 violations of probation and the administrative rules, or orders that have been signed, I recognize you don't have jurisdiction at this point
That's correct.
to enter orders on his bonds for violation, so I'll have to address that before Judge Haynes.
All right, so Mr. Etienne, what your attorney very eloquently is letting us know is that, one, the trial judge in your circuit case is having you held no bond on 2 separate cases. When you combine that with the fact that you're alleged to, and I don't want you to say anything, introducing contraband into the jail facility, which was located as a result of a strip search, he's powerless to do anything, and quite frankly, so am I. Having said that, on count 1 ROR, count 2 ROR, count 3 bond in the amount of $1,000, and 4 and 5 will stand no bond. Good luck, counsel.
Did you get a finding of finding?
I do find probable cause based upon the probable cause affidavit, which specifically indicates that as a result of the strip search, they found the contraband.
Thank you.
You too.
Ms. Carpenter, good morning to you, ma'am.
Good morning, Judge. How are you?
What case do you have, Debbie?
Kirk Loud, L-A-U-G. It's a reset from yesterday. So I'm
Loud?
towards the end of the document.
Lau. So it's in here towards the end.
That's what I understand, Judge. I've read the probable cause affidavit.
Third from the bottom.
We're all good today.
All right.
It's good
Lau,
Friday.
I got it.
Thank you.
Good morning,
Judge, my
Debbie.
argument with regard to the charge of burglary of an occupied dwelling unarmed is that the probable cause affidavit fails to establish probable cause for that charge. If you look at the allegations, Mr. Lau was a passenger on the handlebars of a bicycle when the officer attempted a traffic stop saying that was illegal. I'm not sure that that is in fact illegal, to be on the handlebars of a bicycle. However, I'll address that issue on another day. I think that the stop was illegal. The allegations are that Mr. Lau ran from the officer after getting off the handlebars, that the officer chased him into a backyard of a house where he apparently was alleged to have gone over a fence and damaged the fence. I don't believe that meets the elements of burglary of a dwelling. I ask the court to find no probable cause with regard to that count.
He's charged with breaking or injuring a fence.
Yes.
Yeah.
Is that a new statute?
I've never seen it. I'm
I mean,
frankly.
this is not my first rodeo. It's the first time I've ever seen
And
the
it's not
criminal
my first
offense
rodeo
of
either.
breaking a
I've
Yeah,
never
fence.
seen
normally,
33 years.
and normally, Your Honor, I mean, I would imagine normally in these type of circumstances, it does mention some damage to the fence, and I would think a criminal mischief.
810.115.
Do you have a statute
And-
book? Is that-
I don't know. It's not my courtroom.
I didn't look it up because I haven't had a chance to. Is that a
You have piqued my curiosity, State.
I'm gonna, Your Honor, I don't think it's gonna be in the statute book. I'm gonna Google this.
So the state doesn't think that this statute.
The Florida criminal statute, they leave some statutes out because, frankly, they're just not
Because there's only so much
used very
paper,
often.
right?
Exactly.
Yeah,
There you
okay.
go. All right.
Carpenter, could you see if
I'm looking.
810.115 injuring offense is out there?
115, breaking or injuring a fence.
There you go.
There is a statute
Oh,
on
yeah.
that.
Yeah, whoever willfully or maliciously breaks down, injures, defaces, cuts, or otherwise creates or causes to be created an opening, gap, interruption, or break in any fence or any part thereof belonging to an enclosed land, not his or her own, causes to be broken down,
And if you do it twice, it's a felony.
misdemeanor of the first degree.
Is there like an add-on if you do it the second time that ups it to a felony?
Third degree felony if you do it twice.
And if it's used to contain.
That seems like one of them statutes that might be for North Florida. I know it applies
Well,
everywhere, but you know,
it
you
says-
break into the farm sort of
It says
thing
if
and
the fence
cows get
contains,
out.
it's this. There's another subsection. If the fence contains animals, it is a felony.
Yeah,
Right.
okay.
So it's
I got 20 some odd years in the
Aren't you?
system. I didn't know it was a crime to break a fence.
Aren't you
All right.
glad you came in today?
So let's talk about this whole burglary thing. This looks like fleeing,
And
resisting.
And Your Honor, I think technically it satisfies the elements of burglary that he unlawfully entered someone's property while committing offense, thereby, as you stated, obstructing or resisting an investigation. Now, granted, I spoke with Ms. Carpenter-Toy about this. It's not as serious as someone breaking into someone's home to steal property. I understand that. And I would certainly understand the court taking that into consideration when setting a bond or release
Count
conditions.
one's going to be an ROR, Ms. Carpenter. Count two, breaking and injuring the fence. ROR. Count three, resisting without priors.
Your Honor, he pled out a resisting without violence from last year. He pled that out February this year. I'm showing he has a pending burglary structure, burglary conveyance, and obstructing fire equipment. That's all I see as far as Broward, Your Honor.
I represent him on that pending case before Judge Robinson. I don't think this case is going to be filed, so I'd ask the court to consider setting the bonds up and deal with that.
All right, I'm going to set bond on the,
What address are you looking for?
on the
His
misdemeanor
address?
amount of $500. On count three, 1 and 2 ROR.
Count four.
Count four, I don't think that's a monetary
That's a
bond. I don't
infraction.
know that it's a criminal offense that I can associate a bond for riding on a handlebar.
We just enter something so that the jail sees it. Okay, not
It's
for
it's already entered in that it's no bond attached.
All right, Ms. Carpenter, have a good day.
Thank you, you too, Judge.
Bye. Thank you for enlightening me. All right, jail, we're gonna be off for a little bit. Apparently I have a whole bunch of, our counsel, do you have a case as well? I'm sorry.
Good morning. Ariel W. Berger on behalf of the Office of Statewide Prosecution.
Okay.
James Patrick Perez.
You're up.
Go down Mill to
All right, James Patrick, step up.
Your Honor, Patrick Perez James, he's represented by Mr. Giletti. Looking at the first page of the booking report, it doesn't indicate it's a Nebbia, but if you see page 6 of our warrant, there's a Nebbia on each count. I'm working on that with Mr. Giletti, but at this point, he does have a Nebbia attached to each count.
Yeah, I'm looking for it.
It's Patrick James. James is the last name. Sorry.
Yep. James Patrick.
Too far?
Where's the big bill? He's out there.
There's Richard.
There we go.
James Patrick, or Patrick Perez James, is how I have it.
Just call Steve.
And you're on page 6 of the packet is, we went in front of the Honorable Judge Usan, and we have a nebia attached to each count. It just didn't make it on the booking report.
All right, well, on count 1,
Yeah, I guess.
listed bond is $7,500.
That is correct. With the
Count
nebia.
2, says his bond is $5,000 with a nebia. Anything else I need to do at this time?
No, Your Honor, he's represented by Mr. Gilletti, and we're working on the
If
nebia
it's
packet.
unwarned, does she have to do?
All right,
separate
sir,
order?
so you're going to remain in custody for a
it's
little bit.
on
They're
warrant,
trying to
fine.
put some stuff together. Is the count 1, your bond's $7,500, count 2, your bond's $5,000 with a nebia. Anything
Does
else?
she have to do
No, thank you, Your Honor.
Thank you for coming in. Have a good day.
Thank you, too.
All right, so once again, we're going to be off the record for a little bit. I need to address these these dependency shelter hearings. BSO, I'm sorry, we appear to have just a whole bunch of cases, so I'll be back with you as quick as I can. All right, good morning, everybody. My name's John Fry. I'm a judge here in the 17th Circuit. You're here for a magistrate hearing. Let me explain to you a couple of ground rules. One, everything you say is being recorded both via video and via written word if it was reduced. You need to understand when you come up here, this is a non-adversarial hearing. What does that mean? That means we are not fighting about the written word. What we're fighting about is whether or not that written word is a legal basis for you to be charged with the crime and held. The Florida Constitution is relatively clear. It's exceedingly clear in that it indicates that I am to use the least restricted method to ensure your appearance in court. Having said that, there are a number of specific cases and a number of specific reasons that defendants are held no bond. If you're here on a felony warrant that's a no bond warrant, you're going to walk out of this courtroom or that jail room with a no bond warrant. If you're here where there's a potential monetary bond, you may hear me asking some questions. I assure you they're not geared towards you unless I specifically ask you this question, and anything I ask you, you're under no obligation to respond to. However, I would ask you to bear in mind that if I ask you a question, it's generally going to result to your benefit if the question I'm asking is true. Having said that, if you don't want to tell me where you live, you don't have to, at which point I will quite frankly assume that you live in Timbuktu, and that's one of the conditions that will count against you for purposes of bond. We're going to go relatively quickly once we get going. Are we prepared, Madam Clerk? All right. So, Sophia Tirado. At Paul Ryan.
Just right to the podium.
All right. Ms. Tirado, my name's John Fry. Good morning to you.
Good morning.
All right. I want you to listen to what I'm telling you, and don't say anything until I tell you otherwise, okay? You were arrested by Officer Kyle Woolley of the Margate Police Department. Do you understand what I've just told you?
Yes.
Long time ago in a land far, far away, Kyle Woolley was a young man, and he was the ring bearer at my wedding. He's also planning on getting married in about 4 to 6 months, and I will be performing the wedding. You have the absolute right to ask for another judge to hear this, at which point you will be held until we can get another judge to hear it. Today is a holiday. Otherwise, I would get a judge for you right away. Do you understand?
Yes.
Okay. So would you like another judge to set your monetary bond, or would you like me to set your bond knowing and understanding that you won't see another judge until tomorrow morning? Ma'am?
Is it possible for me to make an argument for release before she answers the question?
Yeah, absolutely. You may proceed.
Okay, reading the probable cause affidavit, the likelihood of sudden conviction is very low. She is engaged in alleged victim. The alleged victim did refuse to take photographs. He refused to provide a sworn statement, and he refused medical treatment. I did speak to Ms. Tirado. She has a residence with her mother in Deerfield Beach. She's been living here for 10 to 12 years. She has a job at the Westfield Broward Mall. And if Your Honor will be inclined to release her ROR or on pretrial.
Who are you, sir?
So I'm Joseph Bovado. I'm her fiance.
You're her fiance. And you want to speak about this as well?
Yes, sir. I actually wanted to.
All right, I want you to use caution because, I mean, just looking at you, I see a cut on the side of your face.
So that's something from I do a lot of jiu-jitsu, so it's just.
You do a lot, so you're a martial arts sort of guy?
Yes.
All right, well, at this point, I need to stop. Counsel, would I consider that? Yes, absolutely. But I don't think it's appropriate of me to do so until I give her the opportunity to have me step off this
Just
case.
wanted to make my argument.
Ma'am, so your boyfriend, I guess, is here as well. The public defender's making a very skillful argument on your behalf, but we don't have a decision. Do you want me to set your bond, which is a monetary amount that would have you released, or do you want to sit in jail until tomorrow when I can get another judge in here?
The bond, sir.
Yeah, this is probably a wise choice, young lady. All right, state any priors?
No, Your Honor.
All right, young man, what do you want to tell me?
I just wanted to say pretty much that requested, I know that I don't have any say, but I just wanted to request, the charges to be dropped. I know that this was just a one-time incident. I understand that there's been a lot of, financial.
This is not the forum for the charges being dropped. What I'm trying to figure out is her level of threat, not just to you, but the community as a whole.
Whatsoever, sir.
How long have you been dated?
Sir, we've been together for almost 3 years, actually.
Do you live in the same place?
Yes, sir. We actually have an apartment together. We just haven't had the chance to change our addresses.
Do either of you have family in the area?
Yes, sir.
Who has family in the area?
Hopefully.
All right, so here's my question for you. Do you want to move out or have her move out?
I'd rather, if I have to move out, just for her to have the place, I will do that. I mean, I know that we legally have a lease together, and I want to.
It's for short term, hopefully, until you can work through it. But until I can make sure the situation is safe, you two aren't residing in the same place. Because I have to take a snapshot based upon a 2-page document and the information I'm getting, which includes the information I'm getting from you. State your thoughts.
Your Honor, the bond I'll leave is solely in the court's discretion. I would just ask that there be a no contact order imposed.
Ma'am, do you have a job?
Yes, sir.
All right, do you have the ability to come up with $500, either you or your boyfriend? Sir, can you come up
Yes,
with
sir.
$500? All right, the bond's going to be set in the amount of $500. I'm going to order a no contact order. Now, let me explain. All right, you want to tell me something?
Yes, I wanted to actually talk about the no contact. If there was any way to.
There is. She gets a lawyer. The lawyer goes in and sorts through it. I understand that you're not in fear, but if what your words were, this was only a one-time incident.
Yes, sir.
Now, hang on. You're not helping her. All right. What you're telling me is that there was an incident. It can't be a one-time incident unless there was one. So we have to sort through that.
I understand this. Sir.
I'm not looking to hurt your girlfriend. I'm not looking to hurt you. I would love for you to get married, and heck, I can do your ceremony right after I do the officer's ceremony. It doesn't matter to me. But when it's all said and done, I'd like you both to be alive with all your appendages.
Absolutely, sir.
All right? So I'm going to order no contact. Now, I want to caution you. You are going to form this, you're going to have an epiphany where you're going to decide that since you live there and you two are getting along, that you're going to go back in the house. At which point, she's going to go to jail for violation of my orders. So no contact means no contact. Do you understand that? So I need you to vacate the house. What city do you live in?
North Lauderdale.
North Lauderdale. So you need to go home, get some stuff for a couple days, all right, and then get out of the place, all right? I'm going to allow limited contact state for the sole purposes of coordinating when she won't be there for him to go get stuff as he needs it. Any objection to that?
Your Honor, would you make the contact by telephone?
Yes, by telephone.
I'm fine with that.
You can talk to her on the phone, not about this case, because that's witness tampering.
Yes, I understand that.
All right, but about if you need to go back to the house and get stuff, okay? Young lady, I'm going to set your bond at $500. Your boyfriend indicates he's going to pay the $500. I'm ordering you have no contact with the victim, your boyfriend in this case. I'm going to allow you to go back to the house, but if he changes his mind and decides he's going to come back to the house, you have to vacate it. You two are within, what do you want to say, 500 feet? 500 feet of each other, it's going to result in you going to jail. Do you understand that?
Yes, sir.
Good luck, young lady. Court finds probable cause.
Thank you, sir.
Thank you, sir.
Okay. Kelsey, I'm sorry, we're going to skip that. Edwin Mendez. Edwin Mendez. In jail.
Gutierrez Guillermo.
Good morning, Your Honor.
All right. Good morning, Mr. Mendez. On count 4, having violation of injunction for protective order on domestic violence. It's alleged that there is a protective order in Miami-Dade County. On that particular charge, I'm going to have you held no bond. As to count 1, the touch strike battery, I'm going to set your bond in the amount of $1,500. As to count 2, the resisting officer without violence by allegedly lying about all kinds of stuff. I'm gonna set your bond at $1,500. On count 3, I'm gonna set your bond at $1,000. I'm gonna order no victim contact.
Your Honor, if there's just one thing I could advise the court about, it might affect the bond that you already set on count 1. It actually is not an injunction. It's a no contact order. He was arrested March 7th and has a pending domestic violence case against this victim in Miami.
Is that on count 1 or count 4?
Count 4. It's a violation of pretrial release conditions.
Okay.
From a domestic violence case
Do
in
you
Miami.
understand I ordered him no bond?
No, I understand. I'm making a record on it just
Okay,
to bring it to your
thank you
attention.
very much.
That's all.
He was trying to get you worse.
Good luck, Mr. Mendez. Richard Kramer.
Oh.
Right out the middle.
Mr. Kramer, you're charged with 1 count of domestic battery by strangulation. I've read the probable cause. I find your bond to be $2,500. I order no victim contact of any kind. If you have contact with the victim, it will result in you being rearrested. Good luck, sir. James Jenkins. Jenkins.
He's not here. Go out.
Mr. Jenkins, there's 4 counts against you. Domestic battery by strangulation, grand theft, trust strike battery, and tampering in the 3rd degree of felony. All right, the court does find probable cause. On count 1, I'm going to set your bond in the amount of $5,000. Count 2, I'm going to set your bond in the amount of $5,000. Count 3 and 4, I'm going to release you on your own recognizance. Good luck, sir. No victim contact of any kind. Jason Matthew or Mayhew. Jason Mayhew.
That's a medical reset, Your Honor.
Medical reset. Terrius Humphrey. Darius Humphrey. Mr. Humphrey's charged with a violation of felony probation. No bond. All right. B. Valado. Where's Vlado at?
Main jail, Your Honor.
Hello, Miss Vlado. How are you?
Hi. I'm good. How are you?
Ms. Vlado, I'm going to give you the opportunity, should you choose to do so, to resolve this case today. If you don't want to resolve this case today, I'm going to release you on your own recognizance. So in other words, either you can resolve it today or you're going to get out of jail to fight it. What do you want to do?
Get out of jail to fight it.
All right, enter a plea of not guilty. Release the defendant on her own recognizance. Good luck to you, young lady.
Thanks, sir.
All right, Jennifer Ingram. Ms. Ingram, you have an outstanding capias in the amount of $1,000. You also appear to have a court order on a 2014 felony. Somebody explain that.
Your Honor, this is.
Going her way, Your Honor.
Okay, thank you. All right, we'll put it to the side for a couple minutes.
Sure.
Camry Cooper. Are you Camry Cooper?
Yes, sir.
Yes, sir.
All right, good morning to you. You have 2 felony warrants, no bond. You're remanded custody of Sheriff of Broward County, no bond. Good luck.
Hello, Judge.
All right, Kelsey Howe.
Kelsey, come up.
Your Honor, Ms. Howell has advised that she has a private attorney and would like this reset until tomorrow where he can be present.
Who's your private attorney, ma'am?
Roger Elkin.
Roger Elkin, state.
I have no objection.
All right, ma'am, we're going to reset this until tomorrow for you. Good luck, young lady.
Thank you.
Crystal Helms. Ms. Helms, you have a violation of probation, no bond warrant. Good luck to you, young lady.
Thanks.
Lynn Berry. Ms. Berry, the court's read this probable cause affidavit. It's alleged that the child wandered off and was found several blocks away. State your thoughts.
Your Honor, I'm sorry, one moment.
What? That one more time?
It might have gotten attached to other paperwork.
All right, put a little circle around it. We'll figure it out. I'm not going to spend 5 minutes trying to figure it out. State, any input on Barry?
Your Honor, she has no priors. However, obviously, I am concerned for the well-being of her child based on these allegations, Your Honor. I would be asking for a $5,000 bond, and as far as context, she would have to comply with whatever orders the family court judge sets as far as visitation.
Is this in family court right now?
Your Honor,
I mean, if this incident just occurred and the state of Florida had taken this child, I would have met this child or at least had this case called in the last hour or so.
and that's why I suspect there was one case mentioned earlier, Your Honor. I believe, can we go cyber? I don't want to put the child's name out there.
All right.
Was there?
Hang on 1 minute.
Yes.
All right, ma'am, I'm going to ask you a very simple question. I need you to tell me the truth, okay? All right, it doesn't adversely affect you, and if the state of Florida was to attempt to use this question against you, I find prior to asking it, you were under duress when I asked it, so they can't use it, okay? The attorney can explain that to you.
He's gonna make you answer it.
Do you know somebody by the name of Garcia?
Yes.
Okay. The only reason I'm asking is I'm trying to figure out what's going on with the kids, and I'm trying to tie a series of things together. I wasn't doing it to give you a hard time. She has no prior criminal conduct, correct?
None that I see, Your Honor.
The children are in the care or custody or being looked at by the state of Florida through the Attorney General and BSO, correct?
I believe so. What I'm also going to do, Your Honor, is in an abundance of caution, I'm going to reach out to the officer in this case to confirm that CPS was contacted.
All right. Madam Public Defender, I'm going to go off record for about a minute. I need you to try and ascertain from me as an advocate, without it being used in any way, shape, or form, if the state of Florida has a child at this time, okay?
Yes, sir.
All right. I think we know the answer. I just need to be sure. We'll be off the record for a minute.
Of DCF.
All right, we're going to be back on the record. So, Madam Public
Your Honor.
Defender, do we have any idea at this time, and I'm not minimizing it, but the question might not come out quite the way I want it, where the child is now?
My understanding from the answer I've received is that DCF would have had the custody, but has placed them in the care of someone else.
Okay. All right. Ms. Barry, you live here in Broward County?
Hallandale.
All right. Do you have a place to stay?
Yes.
All right. I'm going to put her on pretrial. Any objections, State?
No, Your Honor.
All right. Ma'am, we're going to let you out without a monetary bond, but we're going to supervise you, okay? Now, I want to caution you about one thing. I heard this case when we were waiting from a dependency standpoint as to the child. All right. One, there's going to be a hearing on Monday. So you're going to need to be back here on Monday in front of Judge Porth. All right. He's over on the 7th floor in the new building. And two, My order releasing you is going to require you to do whatever the state is requiring you to do in the family law case. So it's kind of an open-ended thing. If they say you can't see the child, then you can't see the child. And if you violate that, then you violate the criminal charge. So the family law case is going to dictate what happens with your criminal case. Do you understand that? Good
Yes,
luck.
sir.
Good luck, young lady. You'll get out at some point,
Thank
probably in the
you.
middle of the night. Chantel Porcorny. Chantel Porcorny. All right.
North Broward, Your Honor.
North Broward. All right, ma'am, I reviewed probable cause affidavit on count 1. I do find probable cause. I'm going to set your bond in the amount of $1,000. Count 2 is not a criminal charge. Good luck. Regina Crew.
Step away for a moment, Your Honor. Put down a brief recall.
Brief recall, all right. Sharon Shepard.
Brian Becker.
Sharon Shepard, bond her down. Okay, well then we'll ignore the notes that I wrote on her. All right, Nicole Taylor.
You got this car standing up, just third.
Nicole Taylor. Nicole Taylor.
Your Honor, Nicole Taylor's at North Broward, but if the court would, we have Regina Crew back present.
All
The one I
right,
placed
so
on the
hang on,
brief
Taylor's going to be about quick. Hang on.
Taylor's coming, Your Honor.
All right.
Come on, Frederick. Right here on the end.
Ms. Taylor, good morning. My name is John Fry. I'm a judge in the 17th Circuit. The state of Florida has a warrant out for your arrest. It's a no bond violation. Good luck to you. All right, let's address Crew. Regina Crew, possession of cocaine. Ms. Crew, I've reviewed the probable cause affidavit. I do find probable cause. Your bond's going to be set in the amount of $1,000, okay?
Okay.
Good luck to you, young lady. Amit Chinsang.
Morning.
Ms. Chinsang, good morning to you. I've read your probable cause affidavit. I gotta tell you, you're a threat to society. All right, according to count 1, I'm gonna place your bond on that one count at $10,000.
No, not yet.
All right, that specific charge has to do with you using a fictitious New Jersey driver's license to fraudulently steal an iPhone. Count 2, I'm going to release you on your own recognizance. Count 3, I'm going to release you on your own recognizance. Counts 4, 5, and 6 having to do with other stolen and fraudulent IDs. $10,000 per count. Your bond's $40,000. Good luck to you, young lady. Tara Maglicio.
Your Honor, she's going to be a medical reset.
Medical reset. Thank you. Terry Jones.
Conti.
State, any objection to me ROR in this person?
Your Honor, the only issue, and it's really more for his benefit, I see it's count 22. If he's being held on other stuff, what'll happen, since this is a satellite case, if you ROR him, the clerk will give him a new date in North. If he's still in custody, he won't be able to make that date. And
Mr. Jones, I have a question for you. I promise you I'm not asking it to hurt you, okay?
Yes, sir.
You have a whole bunch of other counts, right?
Yes, sir.
All right, I'm going to set your bond on this particular charge. I was going to release you, but for the fact that you appear to have 21 other counts. So I'm going to set your bond on this case at $50 so they stay together, okay?
And now he'll get transferred to Central.
All right, so now that case will be transferred to Central in total. Good luck to you, young man. Stephen Gaffney.
Conti.
Mr. Gaffney, you have a warrant out for your arrest. Bond set in the amount of $500, sir. Do you understand?
Yes, Your Honor.
All right, good luck to you. Jamie Gardner.
Conti.
Mr. Gardner, this appears to be count 4. That means there's count 1, 2, and 3. I'm going to set your bond at $50 on this case so they all stick together. Good luck to you. Christopher Batman.
Conti.
Mr. Backman, you appear to have
Yes,
two
sir.
additional charges as well. This is an ad charge, so I'm going to do the same thing for you. This is apparently, well, no, this is unrelated. It's a misdemeanor capious
It's
on
a
an
municipal.
MO.
Yeah, it's municipal ordinance.
I'm going to ROR him on count 4. Sir, I'm going to release you on your own recognizance. This is municipal ordinance. It's an alleged city violation. I have the authority to modify your release, so I'm going to release you on your own recognizance on this. It appears to be a Hollywood case, so I'm not going to make you sit in jail. However, your other 2 counts do affect you, all right?
Yes,
Good
sir.
luck to you, sir. Ellie
Thank you.
Didier. Ellie Didier.
Conti?
Didier, you apparently have 6 additional counts. Do you understand that?
Yes, sir.
All right.
He's,
State, what are the additional counts? Because I
Your
read
Honor,
this probable cause. It gives me a little bit of angst.
Your Honor, I believe he's just here on 7, 8, and 9.
Okay, what are 1 through 6?
He one. If I could just have one moment, Your Honor.
This is the case where apparently there were 3 lanes of traffic and cars spinning and cars going in lakes and all kinds of stuff.
Your Honor, if I may, I'm looking here. 1, 2, and 3 are resisting without violence, reckless driving, leaving the scene. Can I have a moment to make sure that these aren't?
Sir, I'm going to
didn't
have
get
you
doubled
stick
up
around
on?
for a couple minutes because these might be duplicative charges, so we want to look at them, okay? So just,
Okay.
not that you can go anywhere, but stay there for a couple minutes, all right?
Okay.
Daniel Sherman, Daniel Sherman. Good morning, Mr. Sherman. All right, this
Morning.
appears to be 1 count possession of drug paraphernalia. Nate,
Yes, Your Honor.
Mr. Sherman, I'm going to ask you a question, all right? I'm not asking it to hurt you, I promise. If I'm asking you a question to hurt you, I'll tell you that first, all right? Are you on probation?
No, sir.
Are you on any government release?
No.
All right. In reading this report, and I'm not saying it's true, but I'm going to read a couple lines to you, all right? I don't want you to answer this yet. Do you understand that? All right, so she's
Yes,
going to
sir.
push that button, turn that off right now so we can't hear you. All right. According to this, when the cops caught you, you said, "It's my crack pipe, but I smoked all the crack already." And then in addition to that, you said, "I'm sorry I ran, but I didn't want to go to jail." So you seem like a kind of honest fellow. All right, now you can turn that button back on.
Happened here.
So you have an
This is his first
absolute
appearance.
right to legal representation by the attorney you're choosing. If you couldn't afford an attorney, I'd appoint one to represent you.
It's the
All
same
right, if
exact
you wanted to
PC.
resolve this case today, I have the authority statutorily to do it, and you'd be done with it. My train of thought is
Would
that
love
I'm
to
going to
resolve
offer
it.
you a withheld adjudication, $293 in court costs, and close this case out if you want to resolve it today. Now, I need you to
I would love
understand that
to.
if you resolve it today, you're giving up every right known to man. All
I
right?
understand that,
You
Your
can't
Honor.
fight how you were
Wait, hold on a
charged. You
second.
can't fight how they
'Cause I see
stop
that
you.
this
It's,
one
it's a plea of convenience
notarized
because
by
you don't
someone
want to come
different.
back again.
Understand, Your Honor.
You interested in doing that, or you want to fight this?
I'm interested in doing that.
Anybody threatening or forcing you, making you do this?
No, sir.
How long you been in jail today? When'd you get picked up?
Yesterday.
Yesterday, so you've got at least 10 hours in there?
Oh, I got at least probably like 24 hours.
Okay, so there's no drugs or alcohol in your system, is there?
I'm
Nope.
gonna tell
Do you
him.
understand
sir.
everything I'm telling you?
Yes, sir.
Are you waiving your right to legal representation by the attorney you're choosing?
Yes, sir.
You understand if you're on probation, parole, anything of that nature, anywhere on planet Earth, the entry to this plea is going to violate that probation or parole.
Yes, sir.
Anybody threatening or forcing you, making you do this?
No, sir.
How do you plead?
I plead no contacts.
Withhold court cost. Have a good day, sir.
We can go back to
Yes,
Mr.
sir.
Didier.
All right, you want to go back to Didier? All right, we're going to go back to Didier. Where's Didier?
Conti, Your Honor?
Conte. All right, State, what have you found out about Mr. Didier?
Your Honor, Mr. Didier appeared before Judge Zakor this past Monday, basically it's the same PC affidavit. The officer added some more, but I'm not confident enough that there's enough additional to support these 3 new charges. I have no objection on the court RORing him on these 3 counts.
All right, Mr. Didier, we're not sure if it's not out of the same incident, so I'm going to release you on your recognizance of all 3 of these charges. You still have your bond on your other charges, but your bond's not going to go up as a result of these charges. Do you understand that?
Yes, sir.
All right, good luck to you, RR. Paul Woodward.
Good morning, Your Honor.
All right, Mr. Woodward, you have a misdemeanor capias. Your bond set in the amount of $500 for a violation. $500 your bond. Good luck to you, young man. All right. Wiley Thomas.
Willie Thomas?
Willie Thomas.
Willie Thomas.
Yeah, Willie. Yes, sir.
Mr. Thomas, good morning to you. I've read your report. You're charged with petty theft, resisting, and a municipal ordinance violation. Allegedly, when you were arrested, your response was, "Fuck that shit, baby." When you were placed in handcuffs, you refused to walk. You refused to get in the police car. You pushed and forced the police car as you resisted and braced to prevent going into the car. So that causes me a little bit of angst as to your willingness to participate in the criminal justice system. As such, on count 1, I am going to release you on your own recognizance. On count 2, I'm going to make your bond $1,000 instead of $100. Good luck to you, sir.
I don't have any money, sir. Could I resolve it today?
He just raised your bond.
How long you been in jail?
2 days?
Yeah, I wouldn't resolve it today if I was you. I'm just thinking
I
out
would like
loud.
to.
No.
Yeah, I wouldn't do that if I was you. This is me telegraphing a hint to you.
Thank you.
All right, have a good day, sir. Our arm on the MO. All right, John Loayaza. I'm sorry, I mispronounced that, I'm sure. All right, so you're charged with resisting an officer, assault on an officer, and trespass.
Second row, there's a note, in the same order.
Your Honor, I would ask the honor to sign that order for the telegraph office to take photographs.
Absolutely. We're going to enter an order so that we can get pictures of you, okay, sir? I think that's important for you because the allegations are basically you picked a fight with the police, dropped to the floor, kicked your legs out, were swinging at the cops as they were attempting to place you in the vehicle. Again, I'm not saying that's true, sir, but that's what the allegations are. Based upon those allegations, you're well, count 1, I'm going to modify your bond. Your bond's going to be $1,000. On count 2, I'm going to modify your bond. Your bond's going to be $1,000 instead of $100. Count 3, I'm going to release you on your own recognizance, sir. Good luck to you. Jose Hurtado. Mr. Hurtado, you have a capias in the amount of $100. Let me see what it's for. Oh, my goodness. State, let's see if we can resolve this. This gentleman, had a beer.
Is this a municipal ordinance, Judge?
Is it an MO?
Yes.
All right, Mr. Hurtado, do you want to resolve this beer case? Or do you want to fight it?
No.
Do you speak English, sir?
A little.
A little? What language do you speak?
Spanish, Your Honor.
You got a Spanish translator around?
I don't know why they're not.
Okay. State, I'm going to talk to him in Spanish and translate. You okay with that?
I'm out of this one.
You out of that one, PD? You okay with it?
Oh, okay.
All right. Señor, buenos días. ¿Cómo está?
Bien.
Ok, escúcheme, ok? Mira, usted está cargado con un cuenta. La cuenta que usted está tomando un cerveza. ¿Entendés?
Sí.
Y aparentemente, escúcheme, cállese. All right. Aparentemente usted está tomando y no va a la corte, ¿entendés? ¿Sí or no?
No sé.
Sí, that's a C. I can see you saying C. So, usted creo fin este caso, hoy yo puede fin este caso con un multa de $50, ¿entendés? ¿Usted cree fin de este caso y entra un plea de no contesta? ¿O usted cree pagar un multa y salió de la cárcel y tenemos que ir a la corte otra vez? ¿Qué prefiere?
¿Cuál de los dos quiere? ¿Quiere arreglar el caso hoy día o pelear?
No, no, que no, gracias.
Wants to resolve it.
He
Okay.
wants to resolve it, Your Honor.
No, yo no puedo tomar ahí, ¿no?
All right. Señor, ¿usted está ahora en probatorio o algo así?
¿Está
¿Usted es
probatoria?
No, 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 no.
¿Nada?
Nada.
Ok, usted sabe que usted no está un citizen de los Estados Unidos, usted puede ser deportado.
No, yo vivo
¿Usted cree, de qué país es usted?
cubano.
Cubano, ok. Mira, usted sabe que ahorita tal vez la situación cambió y usted puede ser deportado si usted entra a este plea hoy. ¿Entendéis este?
Sí, sí.
Y todavía usted cree fin de este caso.
Yo sé.
Ok, ¿usted cree un abogado?
No,
¿Seguro?
seguro.
¿Usted está borracho ahora?
No.
¿No? ¿Entendéis todo lo que yo dije en español?
Sí, yo sé.
Es bueno por un gringo, ¿verdad?
Yo sé.
Ok, está bien. How do you plead? ¿Culpable, no culpable o no contesta?
No contesta.
No contesto.
Okay. Withhold $50 on the municipal ordinance. Lift the bond. Have a good day, sir. ¿Qué estás tomando?
Oh, ¿y ese qué tomaban?
Cerveza.
¿Qué tipo?
Curacén. Es la cerveza en lata.
Okay, have a good day, sir. David State, I know you don't have a dog in this fight, but for purposes of the record, the court makes the following legal findings. One, the state is under an obligation to produce a translator. For whatever reason, because today is Good Friday, the translator didn't appear. Two, the state of Florida, the spoken language is English in the state of Florida. The court fully agrees with the fact that the spoken language is English in the state of Florida. Three, in the interest of justice, the court made a conscious decision in light of the fact that we were remanding a defendant in custody and didn't have an available approved translator that I would take it upon myself to do so. I believe I have the authority. I've actually talked to Supreme Court justices about this very issue, and so I consciously made that decision. If the state's mad with me, I'm really sorry.
Your Honor,
David Williams.
based on the circumstances, I have no objection whatsoever.
6 months. Mr. Hurtado, the pay is $50.
I gave that impression.
No,
Okay.
we're off the record for 1 second. Yeah. All right, so now we're going to be on David Williams. David Williams. Mr. Williams,
sir.
good morning. Mr. Williams, you're charged with municipal ordinance violation. It's alleged, bear with me for 1 second. That you had a Four Loko fruit punch beverage in public. I'm going to ask you some questions. I promise I'm not doing it to hurt you, okay?
Yes.
But if you lie to me, you're going to pay the consequence, okay?
Yes, sir.
Are you on probation?
No, sir.
Are you certain of that?
Yes, sir.
Are you under kind of federal supervision, parole, anything like that?
No, sir.
Do you want to resolve this case today for a minimal
Yes.
fine or fight it?
Yes, sir. Resolve the case altogether.
Okay, you understand you have a right to an attorney.
Yes, sir.
You understand that I'm going to let you out without paying a penny, so there's no consequence if you want to fight this case. Other than
Yes,
you got to
sir.
come back.
Yes, sir.
Do you want to resolve it or fight it?
Resolve it.
Anybody threatening or forcing you, making you do this today?
No, sir.
You under the influence of an alcoholic beverage or controlled substance to such an extent that your normal faculties are impaired?
No, sir.
All right. You doing this freely, voluntarily, or your own decision?
Yes, sir.
How do you plead to municipal ordinance violation?
No contest.
Withhold $50. Have a good day. Lloydum Gonzalez. Lloydum Gonzalez.
Sir.
Good morning to you, sir.
Morning.
You have 3 outstanding warrants for failure to appear in court. Your bond is $100, $100, and $500. Do you understand that, sir?
Yes, sir.
Do you have the ability to pay that bond?
No.
Count 1's a municipal ordinance. I'm going to reduce that to a release on your own recognizance. Count 2's a municipal ordinance. I'm going to reduce that to a release on your own recognizance. Count 3's a state county misdemeanor. That bond will remain at $500. Good luck to you. If you can't post that bond in 48 hours, they should bring you back again. All right. Good luck. Spencer Pervert. Spencer Pervert.
Copy, Your Honor. Copy.
Good morning, sir.
Good morning, sir. How you doing?
Good. So you have a tattoo that says death before dishonor, huh?
Yes, sir.
I got a tattoo that says the same thing. You ever been to Tennessee?
No, sir.
All right, then we didn't get at the same place. All right, you have a couple of capiases. According to this, your capias have a $100, a $100, and a $25 bond. Do you understand that?
Yes, sir. But, sir, I got the
Be
capias
careful
on
what
the
you
same-
say. Be careful what you say.
Yes, sir. I understand. I got
Hang on, the state wants to tell me something.
Your Honor, he had a pending case. The state filed charges, and we added these charges on. That's where this comes from. He's already being held on a total, but before this, on a total bond of $13,000.
All right, so I'm going to make his bond on all 3 of these $50 so they stay together. Young man, we're going to make your bond on each of these, well, on count 1, $50, count 2, $50, or excuse me, count 5, $50, count 6, $50, count 7, we're going to make your bond $25. Why? So the cases stay together and you don't have to go to 2 separate courts. You understand what I'm saying?
And, Your Honor, you think I could possibly get a reasonable bond for my first $10,000 bond? Because I stay with a single parent, and she says she could pay the bond, but she don't have that much money.
Who's he in front of?
Judge, and
who's the judges?
I'm going to get that for you.
Sir, you'll be in court within the next week, and you can speak to the division judge then, okay?
Yes, sir.
All right, good luck to you. If you don't have an attorney, you may want to speak one as quick as you can. Call the public defender's office. All right, Joel Hooten. Joel Hooten.
Paul Ryan.
Mr. Hooten, you apparently, this is going to be charge 2 of your case, so there's a charge 1. Do you understand that?
Yes, sir.
All right, I'm going to make your bond on this count $50, just so the cases stay together, okay?
Yes, sir.
Good luck to you.
Thank you.
Hang on.
Paul Ryan, you skipped on page 5, Ingham.
Ingham, yeah, we got to go back to Ingham. Is Ingham there now?
And Your Honor,
Good morning, Your Honor.
Good morning.
I believe the court wanted an explanation.
We wanted an explanation. Explain to me.
Your Honor, what's happening is she's being held on 2 separate cases. I believe it's a 2014 case. She's being court-ordered held no bond, awaiting a program.
That's a 14 case.
Yes, it is.
Okay.
On this case, and actually there's a 2015 case also. On this case, Your Honor, she was originally arrested on, I would imagine, possession of controlled substance or some type of possession case. We filed the information, but we changed the charge to possession of methamphetamine, so they brought her back again for...
So it's just a change of charge.
That's all it is, Your Honor.
Does it appear that the trial court would have been aware of this charge when they ordered her to a program? In other words, which came first? Ma'am, if you know the answer to this, I'd be willing to listen to you, but I want you to answer in one word a specific question.
If you want to avoid
you got it? Let me know.
I would think so, Your Honor, because the
Good response, man.
The application date for the program was Thursday. It was yesterday. So I would imagine that the.
All right, ma'am, I'm going to ask you a question. I promise I'm not doing it to hurt you, but if you lie to me, the wrath of God's going to come. Do you understand?
Okay.
Me being God.
Yes, sir.
All right?
Okay.
Don't lie to me. I'm not talking about any of the facts of your case, and I am indemnifying you from answering this question. I'm trying to do the right thing here. Right thing works in your favor sometimes, it doesn't work in your favor other times. You understand what I'm saying?
Right. Yes, sir.
You had that first case, and the trial judge ordered you to a drug treatment program, correct?
Yes.
Okay. Was the trial court aware of this new 2015 change of charge when they ordered you to that program?
Yes.
Okay. The court releases the defendant ROR on the new charge. Ma'am, I'm going to let you out on your own recognizance so you can go to that program.
Thank you.
All right. I know, well, count 1's going to be no bond. Or, yeah, count 4 is going to be an ROR. Count 5, as soon as there's a bed. Where are you going to? Spectrum?
Foundation.
Foundations, that's a good place. Good luck to you.
I heard. Thank you.
Count 5's not for magistrate, but that's the basis of her being held. So count 4, I want to just strike count 5, since it's not in front of me. That's just for my information, right, State?
Yes, Your Honor.
Okay, so this won't affect you going there. Get well.
Thank you.
Good luck. Did we already do him? That was the one-armed guy? What did I set the bond at the guy that broke into North Satellite at?
Which one that is, what's the name?
Who?
David Williams?
Hooten.
Oh. Oh. Yeah.
Did we do Hooten?
Yes, we did. It was an ad charge, Your Honor. It was an ad charge of criminal mischief.
Oh, it was an ad charge of $50.
He's got a $15,000 bond on the burglary.
Okay. What was the ad charge?
Criminal mischief. He would destroy the property.
Okay. Blake Johnston.
Copy, Your Honor.
Remember that.
Sorry.
Yes, Your Honor.
No.
Good morning, Your Honor.
Good morning, sir. In reading your probable cause, I have some angst. According to this probable cause affidavit, you broke into a storage shed. You appear to have 38 other counts, something like that?
Yeah, Your Honor, he's being held on multiple other burglaries. I know at least one of which is an armed burglary that he's being held no bond on.
Okay, on count 39, I'm going to set your bond at, we'll make it $2,500. And on count 40, your bond's going to be set at $1,000. The court is cognizant that you have 38 other charges, otherwise your bond would have been substantially more. Good luck.
I would ask for your honor to sign for screen for mental health.
Absolutely. Let's sign an order to screen him for mental health.
Jeez.
Soto, Abelardo Soto. Soto? Yeah, that's him. I got a picture. All right, you have 2 additional add-on counts, counts 4 and 5. Count 4 is a false owner for pawn items less than $300. Count 5 is dealing in stolen property.
Yes, sir.
Count 4, I'm going to set your bond at $5,000. Count 5, I'm going to set your bond at $5,000. Court finds probable cause. Michael Jones. All right, this appears to be out of the same conduct. Sir, you have 2 additional charges. False owner for pawn and dealing in stolen property. Those are counts 6 and 7. Count 6, your bond set at $5,000 on top of everything else. Count 7, your bond set at $5,000 on top of everything else. Good luck. Christopher Cushman. right, Mr. Cushman, you have
Yes, sir.
two violation of probations, and both of them are no bond. Do you understand that, sir?
Yes, sir.
Good luck to you, young man. Roy
Thank you.
Richards, Roy Richards.
Sir, do you have a family member or brother here?
Good morning, young man. What's your name?
Good morning, sir.
Okay, Mr. Cage, what's your relationship to Mr. Richards? His older brother, okay. What would you like me to know?
Whatever he said, let's just take it, because he's raising.
Still not privy to all of the details
Okay.
of what he's charged with, so I'm needing to put together information.
All right, this appears to have been a fight that went horribly wrong, where it's alleged that your brother ended up in possession of the other person's cell phone. But you weren't there, so you don't know if any of this is true.
Right, but I did see a video of the fight.
Oh, yeah?
Yes,
Okay.
and
Did you see anybody taking anybody's phone?
I did not.
Okay. So, I guess, where's your brother live?
With me up in Coral Springs.
In Coral Springs. To your knowledge, does your brother have prior criminal convictions?
Yes.
Okay, state.
Your Honor, out of the state of New York, 2012, Dutchess County criminal. One moment, just one. Okay. Showed criminal possession of weapon with a previous conviction. (2011) operating a motor vehicle with over a .08 alcohol in his blood, DUI. Your Honor, that's all I see. So I don't see a prior weapons offense. That's just what they wrote there in the system.
Well, this doesn't appear to involve a weapon. It appears to, in the light most favorable state, there was a fight.
Oh yeah, I'm just clarifying.
An HOA sort of situation that apparently spun horribly out of control.
I understand, Your Honor. I'm just clarifying that the record said that there was a previous.
On count one, I'm going to set your brother's bond at the amount of $1,500. On count two, the court has a little bit of angst because it would appear that basically your brother had to get tased. All right.
Don't talk about it.
And apparently with the police trying to break it up, he was still continuing to hit the other gentleman. That caused me a little angst. When the police show up and tell you stop, he's supposed to stop. So, as to the resisting, I'm going to charge $1,000. As to the traffic capias, I'm going to reduce that to $50. Sir, young man, if you can't get out of jail, they'll bring you back in about 48 hours. But brother, just so you're aware, his bond is $2,550. If you have that money, you can go to the sheriff's office and pay a cash bond. If you don't, you can get with the bondsman. And it takes him about 12 hours to sort out of it. So if you can come up with that money to help your brother out, he could be out of jail today. Also, sir, I'm going to order no contact with the alleged victim in this case. That would be the person that you were fighting with. Do you live in that apartment complex?
Yes, sir.
Your Honor, and what I believe might solve this is if you just order that he's not to have any direct contact with him.
Sir, I'm not asking you for the purposes of incriminating you, but according to your brother, it's a video, so regardless of who started or what's involved, could you identify the person that you were in the fight with? Would you recognize him?
Slightly, if I was to see him, yes.
Okay, if you see anybody that looks slightly like him, you need to turn around and walk the other way. Do you understand?
Yes,
You're not to have any contact with the victim. All right, good luck.
Yes,
Young man, you can get him out today if you can find one. The jail? It's the building right back over there with the little teeny tiny windows and the knocking sound from everybody knocking on the window when you walk by it.
I'll show you right
jail. All right, good luck, young man. Bye-bye. Aaron Augustin.
It looks like, what the hell?
Mr. Augustin, count one's a violation of community control. You're remanded no bond. Count two, your bond set in the amount of $2,000. Good luck.
She was
All right, Robert King, Robert King. Mr. King, you're alleged to violation of terms and conditions of your parole. You're held no bond. Good luck to you, sir. Giovanni Quintana Acosta.
Judge Brown, 9 a.m.
Good morning, Your Honor.
Good morning, sir. You have 4 counts here, court order, and a whole bunch of capiases as well. Count 1 is allegedly, I don't want you to say anything because this is serious stuff. Count 1 is armed kidnapping. You're remanded no bond. Count 2 is armed burglary of a dwelling. You're remanded no bond. Count 3 is robbery with a deadly weapon. You're remanded no bond. Count 4, carjacking with a deadly weapon. You're remanded no bond. Do you understand that, sir?
Jesus Christ.
All right, if you don't have an attorney, you can speak with that young lady right next to you. They'll work on helping you do what you need to do to get you in front of a judge. But based upon the information I have and my knowledge, sir, you're a threat to society until we can make some additional judicial determinations. You're remanded no bond. Good luck. Jose Collazo. Jose Collazo.
Yes, sir.
Good morning to you, sir.
Good morning, Your Honor.
According to this, there was a cash register inside of a store. You shattered the front window, went in and stole the cash register. Date priors?
Your Honor, I want to bring to the court's attention, from what I can see. Patrice, if you have my computer's freeze. Oh, I've got it.
Are they in Broward County?
Yes, Judge.
All right. And are you confident he has those 2 open cases?
Yes, I am, Your
Do I
Honor.
have the statutory ability to revoke his release on those prior cases?
Sua sponte, yes, you do, Judge.
All right. Madam Public Defender, I'm going to go off the record for just a minute. All right. I need you to understand that unless you can give me confirmation that he doesn't have 2 open cases, at which point we'll do some more details, I'm going to make a decision right now. Fair enough?
Your Honor, as an officer of the court, I can respond that those are open cases, so
Okay.
there's no need to go off record.
Sir, you have 2 separate open cases?
Yes, Judge.
What is the first case number?
First case number, and this is, the grand theft, 15-14290.
Okay, sir, in case number 15-14290, you were on some form of pretrial release. I do find probable cause in this particular case that in the beautiful city of West Park, you smashed and grabbed stuff. I am revoking your release on that first case. You're to be remanded and remain in the custody of the Sheriff of Broward County, no bond. What's the second case?
Burg structure and theft, 15-10625.
In case number 1510625, CF10A, that's a burglary to a structure, correct?
Yes, Your Honor.
Sir, based upon the new allegations and the fact that you have 2 other cases pending, I'm revoking any and all forms of your release and remanding you to the custody of the Sheriff, no bond, on case number 1510625. Now, as to this particular case, sir, count 1, I'll make your bond $20,000. Count 2, I'll make your bond $1,000. Good luck to you, young man. Mark Brown.
So just sit. I'll be there to see you next week.
Mr. Brown, good morning to you, sir.
Good morning, Your Honor.
You allegedly have 2 felony violations of probation. I'm remanding you to custody of the Sheriff of Broward County, no bond. Good luck. Guillermo Gutierrez.
Good morning, sir.
Good morning, Mr. Gutierrez. You allegedly have a violation of the terms and conditions of your community control. I'm remanding you to the custody of the Sheriff of Broward County, no bond. Good luck. Roland Beckham. Good morning, Mr. Beckham.
Good morning, Your Honor.
Sir, you apparently in case number 15243 MM10A have a no bond warrant. And in case number 146032 CF10A and 155437 CF10A. These are all multiple violations of probation. I remand you no bond on all your cases.
Can I get a reasonable bond?
Can you have a bond?
I said, can I get a reasonable bond or RR?
No, sir, you're a threat to society. We're not letting you out. Have a good day. Have a seat. Joseph Ambrosino. Joseph Ambrosino. Mr. Ambrosino, good morning, sir. You too are alleged to have violated terms and conditions of your probation in 2012, 1/6. Oh goodness, I need a pair of glasses. 2012, 18832 CF10A. I'm remanding you custody, Sheriff Broward County, no bond. Good luck. And John Grassano. Mr. Grassano, good morning to you, sir.
Good morning, sir.
All right, you two are alleged to have violated terms and conditions of your probation in case number 143559 CF10A. Sir, I'm obligated to remand you to the custody of Sheriff Broward County, no bond as well. You'll be back in front of the judge. Good luck to you, young man.
Okay, sir.
All right. Michael Bonilla. All right, Mr. Bonilla, you have an out-of-state warrant for your arrest?
Yes, sir.
From Texas?
I live in Texas.
Where? What part of Texas?
Plano.
In Plano. I spent all my summers in Corpus Christi.
It's kind of far from where I am.
Yeah. At least we had the Gulf, right? Little wind. It's pretty hot in Plano, isn't it?
It is.
Yeah, I would have left too, but unfortunately there's a warrant out for you. Your bond's $2,500. If you can post that bond, you'll be released. If not, sir, they're going to move to potentially extradite you. So see if you can get somebody to post your bond, all right? Good luck to you.
We'll see a judge next week, most likely.
We'll see a judge next week if you can't bond out. Leon Freeman. Mr. Freeman, good morning to you, sir.
Good morning, Your Honor. How you doing?
I'm fine, thank you. I'm sorry to meet you like this, sir. All right, you have 2 violations of probation. I remand you no custody or no bond on both those cases. Good luck to you. We'll get you in a division judge as quick as we can. All right, Gene Surpris. All right, Mr. Surpris, this is the same case where we dealt with the other young lady on earlier, correct?
No. I don't.
No, is this a different one?
Yes.
This is the gas station one versus the highlight one. Have we got this, kid?
I don't know, Judge. I don't even have.
I understand that.
Oh. Yeah, this was. That's why it was reset.
This case is in dependency, correct?
Yeah, it was reset.
All right, Mr. Surpris, what I'm doing is as much for you as it is for the child. I'm just making sure that we're doing something with this child. The court does find probable cause that you neglected your child without great bodily harm, and that it's alleged that you took your child to the gas station. You asked somebody to watch your child for about 5 minutes. Hours passed. Your bond set at the amount of $10,000. I also tracked this case specifically to any and all conditions of the dependency case. If they order no contact with the child or supervised visitation with the child and you violate that, I'm not saying you will, but if you violate the terms and conditions of that as it pertains to your child, it will result in a violation of your release on this case. Do you understand?
Yes, sir.
Good luck to you, sir. I hope things get better for you. Christopher Veda.
He's not gonna lower.
All right, you have 3 counts: possession of alprazolam, DUI, and failure to use due care. Count 3 is not going to be in front of me. It's an ROR. State any indicia this is anything other than a first DUI.
Checking that right now, Judge.
Where is Christopher Veda?
Your Honor, it's a medical reset.
Medical reset, we'll address it tomorrow. Gary Scherer. All right, sir, I want you to listen to me. You appear to have 7 counts. In one of the cases, you apparently, allegedly, and these are all allegations, took 2 Fitbits, and that appears to be about $500 worth of stuff, which means they were the fancy ones with the watch on them, because that's what I want for my birthday. In addition to that, apparently at a different time and location, you removed multiple Garmin GPS units. In addition to that, you apparently went into Target this time and removed a couple more Fitbit watches. In addition to that, you have a warrant out for stealing. I have some serious angst here. All right. Based upon some of the additional information as to drug paraphernalia I see in some of these reports, I think there might be a substance abuse issue. State?
Your Honor, he pled out a grand theft last year in front of Judge Siegel. He allegedly stole 3 Garmin GPS units at Kohl's valued at about $450.
So last year he pled out stealing almost identical items as this.
And he sentenced him to jail with the special condition that he complete the SAP program. So obviously there was implications of drug issues then also. And
Sir, there's nobody in this courthouse that wants to see people sit in jail. At least nobody I'm aware of. All right, but I got to be honest with you. Every indicia I have is that you have either a serious drug problem, or B, rampant theft issues. On count 1, your $750 bond is raised to $7,500. On count 2, your $750 bond is raised to $7,500. On count 3, your bond is raised from $750 to $7,500. Count numbers 4, 5, and 6, those are $1,000 grand theft charges. Each one of those is going to be $10,000. Count 7, I'm going to leave it at $500. Sir, your bond has gone from $4,500 to $52,500 to get out of jail. Sir, I'll sign an order today to give you the first available bed and SAP if we can get that going for you and start working to address some of these issues.
Life skills.
What?
Your Honor, he's requesting life skills.
Okay. We'll give you life skills. You don't want SAP?
No.
they have NA meeting. They have some special thing with NA meetings there now also.
Yeah.
Okay,
All
all
right.
right.
Sir, you need to get an attorney as quick as possible. My goal is to ultimately get you in a portal-to-portal treatment if this is true. It's not to have you sit in jail, it's to address the substance abuse issue. But I have grave concerns if I let you out that you're just going to raid various department stores. So that's why your bond's going to be set so high. Frederick Lewis. Frederick.
He said Frederick Lewis. Frederick.
Frederick. Are you Frederick, sir?
Yes, sir.
Good morning to you.
Good morning.
All right, Mr. Lewis, you have an out-of-county hold no bond. You have a violation on a 2014 probation, no bond. And apparently you have 2 traffic capuses, $250 and $500. So you have multiple no bond warrants in various portions of the state. Good luck to you.
2014.
Gerard Charles. Mr. Charles, you're alleged to have violated your probation in 4 separate felony counts and 1 misdemeanor count. On all 5 of those, sir, I'm going to remand you to the custody of the Sheriff of Broward County, no bond. Good luck. Brian Becker. Mr. Becker, you have an alleged violation of probation in a 2013 felony count. I'm going to remand you to the custody of the Sheriff of Broward County, no bond. We'll get you in front of a judge as quick as we can. Donald Johnson. Mr. Johnson, you have an alleged violation of community control in case number 148893 CF10A. Remand you to custody of the Sheriff of Broward County, no bond. All right. Derek Reavers. Derek, you have apparently a 4-count armed burglary charge. I'm going to remand you no bond on each of those 4 counts based upon a warrant that I have. Oh, well, hang on for 1 minute. Take that back. All right. According to this, yesterday, you went to
Looking for an issue, so you gotta go home.
Okay, according to this probable cause affidavit, post Miranda, you confessed to breaking into 4 vehicles with your co-defendant. Also being with the co-defendant when he broke into a white truck where your co-defendant pointed a gun at the victim. And you all confessed to breaking into 15 to 30 vehicles prior to contact. And you were both holding the gun at various times.
Oh. I'm not gonna say nothing.
Right there on
They found at least 4 separate victims. And one of them, just so you're aware, Madam Public Defender, appears to have involved an actual victim as they were doing the burglary and the pointing of the gun. So that perfects probable cause. Sir, I find you to be a demonstrable threat to the residents of Broward County. State, anything you want to add?
Just the only thing I would ask, Your Honor, and I'd be seeking to have Mr. Reavers held no bond on all counts. Pursuant to the rules of criminal procedure, the court would need to find proof evident or presumption great, but I do believe that standard exists based not only based on his confession, but certainly not limited to that. A gun was recovered. There's apparently evidence obtained from victims. They were found in possession of property stolen from some of these burglaries, Your Honor.
PD, you want to hop in on this? Either one of you?
Judge, I would just ask to refer to the division judge.
Which raises an interesting point, because the only time we're all aware that the appellate courts have weighed in on this issue, and it becomes whether or not I guess, sua sponte, impromptu, to apply the standards of an Arthur hearing.
And I want to, and we've dealt with this, Your Honor, and I hope this would put the court's mind at ease. The state's position is, even if the court, since this is a non-adversarial hearing, even if the court were to find proof evident presumption great, the defense still has the right to seek an Arthur hearing, not only seek an Arthur hearing in front of the assigned judge, but the state must again, since that would be an evidentiary hearing, must again satisfy proof evident or presumption great. That court is not bound by the court's decision today.
On the behalf of the public defender, the state of Florida agrees to be concurring that even if I do find, you have the right to readdress that at your leisure, for lack of a better term, in the form of a full-blown Arthur hearing. If that is in fact the state's position, and they just said it was, so I have no reason to doubt them, I don't know why it's detrimental for me to make a finding at this point. I'd welcome either one of the public defenders to come forward and tell me why I'm wrong. Hearing no response. Mr. Reavers, the court finds probable cause as to all four of these charges. In addition to that, the court finds proof is evident,
Your Honor,
presumption. Ma'am?
Your Honor, I apologize. I was actually speaking with him at that time, so he did not hear the court's question.
Okay, well, there wasn't a question for him. It was a question for you.
I'm sorry, Your Honor.
It's a question for you, not for him.
Okay, what was that?
All right, basically the state is asking me to make a finding that proof is evident and presumption is great, analogous to the Arthur hearing, which we all know the appellate courts have ruled on and given us some guidance on. The state's position is that even if I was to make that finding, it doesn't obviate or eliminate your ability to move forward at any time for a full-blown Arthur hearing, at which point the trial court would be more than able to ignore my decision at this point and release the defendant should the trial court feel I made a mistaken decision or had insufficient information. I don't see where that prejudices your client or the person that Mr. Finkelstein's office is being good enough to stand in and represent in this preliminary hearing. Are you aware of any prejudice that finding would cause to you at this point?
No, I'm not, Your Honor.
Fair enough. So as to count 1 through 4, based upon a review of the information contained in these documents, based upon the alleged confessions, based upon the recovery of the appropriate information, I find the state of Florida has met its burden as to proof being evident, presumption being great. Mr. Reavers, on count 1, you're remanded to custody of Sheriff of Broward County, no bond. Count 2, you're remanded to custody of Sheriff of Broward County, no bond. Count 3, you're remanded to Sheriff of Broward County custody, no bond. Count 4, you're remanded to Sheriff of Broward County custody, no bond. Good luck, young man.
You'll get a
Court's going to be in
division.
recess for about 90 seconds. I have Judge Merrigan on the phone. All right, we're going to be back on the record. Cody Sanders. Cody Sanders. Cody?
Sir.
Good morning to you, sir. You're charged with a violation of probation, 2 counts in a 2015 cases, separate cases. You're remanded to custody of Sheriff of Broward County, no bond, sir. We'll get you into a division judge as quick as possible.
Your Honor, I've advised him of his division date, however he wants to speak to Your Honor.
Sir, I want you to be, sir, listen to me for 1 second. I'll let you speak, I promise.
Yes, sir. Yes, sir.
Everything you're saying is being recorded. There is video of you speaking to me, and there's no take-backs when you tell me something. In addition to that, I don't have the authority to set aside the division judge's decision. So anything that you tell me, I have to disregard. Do you understand what I just said?
Yes, sir.
And I'm not making this up, I promise you. Now, having said that, you're a human being sitting in the Sheriff of Broward County who wants to speak to a judge who signed an order. So I'll let you speak to me, even though it's really a bad idea.
Okay. I'll still say what I have to say.
He's telling you he can't change it. He's still.
You understand there's no take-backs. It's not like golf where you hit it in the water and you get to hit another one off the tee.
I understand completely, sir.
All right, go ahead.
I have 2 warrants.
For the record, the public defender's trying desperately to get him not to speak. Go ahead,
Oh,
sir.
yes, I understand. I have 2 warrants, but they're both.
And also, for the record, I've told you not to speak.
Yes, sir. I understand.
Okay, go ahead.
Basically, what I'm saying is I have 2 warrants, but it's for the same. They were ran. I'm on probation because it was ran consecutive. My probation officer, she drug tested me. But the thing is, she did it in such an amount of time that a short amount of time where the THC most likely it obviously didn't get out of my system.
All right. Anything else you want to tell me, sir?
No, sir. I mean, I just wanted to let you know that.
Well, I appreciate that, but we're back to where I started, which is with all due respect to you, I can't do anything about what you're saying. I can tell you the public defender of Broward County is one of the best law firms in the state of Florida, and they are experienced in this sort of a defense. So when you get assigned to a courtroom, if you can't afford an attorney, get the public defender to represent you. What division is it? Judge Oh, I know Judge Robinson. Okay. Well, I got to tell you, but the public defenders in both those divisions are phenomenal. Get with them and explain your story to them, and you'll go from there. I wish you the best of luck.
Thank you very much.
No, it's. And I think it's going to be Judge Shear. She has a lower case. So
yeah, okay, good luck. Joseph Sardo.
That's what I thought.
Joseph Sardo.
We're going to get to it in a couple cases.
Coming forward, Your Honor.
Good morning, Mr. Sardo.
Good afternoon, Your Honor.
This is the first court date. You're going in front of the judge.
Huh? From Veterans Court? Were you in the military, sir?
Yes, sir.
What branch of military were you in?
Navy SEAL.
You were a Navy SEAL.
That's correct.
What unit were you in as a Navy? Be careful how you answer this question. What unit
Okay.
were you in as a Navy SEAL?
Unit 4.
Unit 4. Where did you go to SEAL school at?
Coronado.
Coronado. What did they call SEAL school?
I don't know what.
Oh, you know the name that they used when you went to SEAL school? What did they call it?
Oh, yeah.
What was it?
What they call it?
Training facility.
Yeah, that's the wrong answer. All right. So I had him in Veterans Court, right? What'd I do then? I left him for Meriden. This is all alcohol-related stuff. Mental health?
I got used to it.
But he was in the Navy.
Yeah, and
I remember he was in the
no,
Navy.
the
He just
problem
might
here-
have forgotten what group he was in.
And the problem is, Your Honor, he I guess missed his first appearance in front of Judge Merrigan when it was transferred there, when it was officially transferred to Veterans Court. So I don't even think they got and were able to get him into any programs or anything.
Did you meet with
2013,
anybody
yeah.
from Veterans Court, sir? I
No,
remember.
sir. Yeah, I'm saying, but they weren't able to do anything
When's
significant.
Merrigan doing Veterans Court again?
Oh, the next day.
All right, sir, you lied to me about being a SEAL, but I remember you were in the Navy. I remember that. We had a big discussion
sir.
about that. All right. And he's already in
13-4.
Veterans Court. Public defender, any
No.
objection for me slotting him to go over to Merrigan again?
Absolutely not, Your Honor.
Done. Sold. Good luck, sir. We're going to leave you in custody. You know what? I'll tell you what I'm going to do. Hang on. And do you have any money, sir?
No, sir.
You have any loved ones to help you get out of jail?
No, sir.
All right, so on count 4, I'm going to modify your bond from $100 to $10,000. All right, I'm not doing that to punish you, but I think you really need some help and some treatment. So I want to make sure that you just don't scoot out of jail and disappear into Never Never Land. All right, go see Judge Merrigan. The doctor there is phenomenal. Both of them are phenomenal. Get some help. Good luck. Court finds that the defendant in and of himself, although he doesn't appear to per se be a threat to society, he's definitely a threat to himself. He's going to get himself killed, and I want to get him some help. So we're going to raise his bond on that case. Tyson Harper.
Good morning, Your Honor.
Good morning, Mr. Harper. I'm sure you're aware at this point you have an out. I tell you, my camera's not that good, but that looks like some good artwork you got there.
Thank you.
Let me see your right sleeve.
Right sleeve.
Anything special on there? It's kind of a blur.
Not that I feel appropriate to show you.
No, it's inappropriate stuff. Oh, wait a minute. I can make it out now. Never mind. Yeah, that's not going to look good on the news. All right, and for the record, I didn't realize what that was until the very end there. All right, Mr. Harper, you're aware you have a 2013 felony you allegedly violated on, right?
Yes, sir.
All right, you're being remanded, no bond. And so we'll get you to the division judge as quick as we can. Good luck to you, sir. You're going to sit in jail for Easter. I'm sorry about that. Luis Garcia Sanchez. All right, this is another one of the cases I dealt with this morning about the child wandering away. Do we know what the bond I gave on the other person on this?
Pre-trial.
Pre-trial?
Yes, Your Honor.
Mr. Garcia Sanchez, I'm going to ask you a question, sir. I promise you I'm not doing it to hurt you, but don't lie to me.
Okay.
Do you have a prior criminal record?
No.
None at all?
No.
Are you a resident of Broward County?
No.
No. Where do you live?
But I'm resident from New Jersey, but I'm from Puerto Rico.
You're from Puerto Rico.
Yes.
All right. But are you like living here?
Yeah.
Until you can get a different place? So you said you don't live here, but then you said you do live here. Where do you live?
Well, I'm resident from New Jersey because I have my license and everything from New Jersey.
Okay.
But I moved down here like four months ago.
All right. Do you have an apartment?
Yes.
Do you have a phone at your apartment?
No. I have a
Okay.
cell phone.
Do you have a cell phone?
Yes.
Can I put him in pretrial? All right. I'm going to put you in pretrial. You have no prior criminal history. Assuming this is true, it's a really poor decision. But I don't necessarily think that we're gonna do anybody any good by putting you in jail. We've already got the child with us. So I'm gonna release you on pretrial. Good luck, sir. You'll be out at some point today or tonight.
No, the only other thing, you made a
Thank you,
condition.
sir.
Well,
All right,
of the-
also, listen to me 1 second before you take off. There's a dependency case. That means the state of Florida is now involved as it pertains to your child. All the terms and conditions that that dependency judge puts in place, you're going to have to abide by. Also, you're on Monday afternoon. You're going to need to go to Judge Port's courtroom. It's on, I think it's 7800 over in the new wing. Madam Pretrial, you want to say anything?
I heard you asking about
No, I just wanted to see if there was any time. Sir, so you got to do what the other judge says, but we're going to let you out, okay?
Okay.
You have to report to pretrial when you get out. Good luck. Tristan
Okay, thank you.
Akers. Tristan Akers.
Bonded, Your Honor.
Bonded. Gregory Lewis. Gregory Lewis.
Good job. Figure it out.
Mr. Lewis, do you have a place to stay, sir?
Yes, I do.
Oh, hang on, I got that 14 violation. All right, on count one, I'm going to make your bond $50. On count two, you're in violation on case number 14-4117 CF10A. We're going to have to remand you no bond on that charge. Good luck to you, sir.
All right, thanks.
Take care. Terrence Thomas. Terrence Thomas. The reason I ask, Madam Public Defender, is because in looking at what he allegedly stole, makes me wonder if he has a place to stay, and that would obviously potentially modify my decision on a bond.
Understood.
So, Terrence Thomas. Terrence Thomas. Good morning, Mr. Thomas. How are you?
Good morning, sir. I'm all right.
All right. It appears that you're in violation of your pretrial or community control in case number 15308 CF10A. You're aware that you had another case, right? In other words, you had a case from a year ago?
Yeah. Yes, sir.
All right. Well, it appears that as a result of that, they're revoking your bond, no bond. As to count two, I'll make your bond $50. Count one, your bond's $50. Count two, I'll release you on your own recognizance. Count three, you're being held no bond. All right?
Okay.
Good luck to you, sir.
Okay.
Wesley Vivi. Wesley Vivi. Good morning to you, sir.
Good morning, sir. How are you? Possibly for me to get at least a retrial.
All right, sir, it would appear that you're on felony probation as well, and this new arrest violates your felony probation. As such, I'm going to remand you no bond on count one. Count two, we'll leave it $100. If you resolve both, I'm sure that it'll affect your bond on the first case. All right, the next case is Ronald Bonin. Ronald Bonin.
Your Honor, he might still be medical reset.
Yes, yes, Your Honor, it's still medical.
Medical reset.
Your Honor, if I may.
Are we running out of time?
No. Since it's a warrant, a VOP warrant, I would just inquire if the court is comfortable just making a determination, passing along. He'll either be brought to, he's on loan right now, and he'll either be out in time to bring him to his assigned judge for his VOP hearing, or they'll have to reset it. They don't like to broadcast it.
Okay, I got you.
Rather than having the clerk never bring the paperwork back every day.
Madam's public defender, either of you have a basis to believe that this warrant from the 2008 case is not valid? Considering I have it sitting right in front of me. All right, the court finds probable cause, remands the defendant no bond on the violation of probation. Does that address your concern, State?
Yes, it does, Judge. Thank
All
you.
right, and Ryan Pottle. Ryan Pottle. Ryan? Young
No
lady, who
problem,
are you here
Your Honor.
for? Never mind. My condolences. Ryan Cottle.
No problem, Your Honor. He's gonna be a medical reset, please.
All right, medical reset. Does anybody have any other cases?
No, Judge.
All right, to the good ladies and gentlemen at BSO, Madam Public Defender, have a blessed and happy Easter. Court will be in recess.
Thank you, too, Judge.
Thank you, Judge.